So this section 2D explain about all three tenses of consideration, yeah? Past, present, and future, yeah? So consideration, it can be from promisor to promisee or promisee to promissor or any other person, okay? So the consideration can be moved from the third party as well, okay? So here are three tenses. Past consideration, executed is right at the moment you are doing it, and the executory is the in the future. So you promise that you are going to do. That's why it's called as that. Promises to do or to abstain from doing something. Such act or abstinence or promise is called consideration for the promise. Yeah. So this is the definition of promise, which explained under the Section 2D of the Contracts Act. Under the Section 26, it is stated as an agreement made without consideration is void. So if you are making an agreement, okay, and if there is no consideration, the agreement will never become a contract. So to become a contract, become a valid contract, consideration must be there. So consideration is, that's why it's called consideration, is the one of the essential elements of the contract. Yeah. So this is what does I mean by the executory consideration, exchange of something between the parties. Promises for a promise for performance. Okay. So you have to do something. So let's say, for example, I promised that I will sell you my car, and you must promise me back that if you promise that, okay, I will buy the car from you. So it is an exchange of promises between the parties. Okay. And then here, there are three types, explanation of three types of consideration: executory, executed, and past. Okay, executory is that in the future, in the near future, that you are going to fulfill the promise. Executed means that you promise to act. Okay, so it is an exchange of promise to an act to be done. It is called as the executed consideration. Past is that you do the act already, and only after you have done the act, then you make the promise. So the promise come after the act was done. That's the reason that it is called as past consideration. So let's say, for example, you see someone drowning. Because you see someone drowning, so you go and save the person. Only after you save the person make the promise. So the act was done first, isn't it? Only after the act was done, the promise was made. So that is the reason it is called as past consideration. Yeah. So the act have to be done first. So this is the situation under in Malaysia, the position in Malaysia. All right, both the past consideration, executory, executed, all are good consideration in Malaysia. No issue about it. However, under the common law, in the United Kingdom, under the common law system, past consideration is not a consideration at all. Yeah. So if it is a past consideration in UK, you cannot sue the other party for the past consideration. Yeah. So let's say, for example, you have done the act already. Only after you have done the act and the promise was made, then that type of promise cannot be fulfilled under the common law. Okay, so these are the definition of the three considerations that I explained to you just now. So this is a past position under the common law. So if one party voluntarily performs an act and the other party then makes a promise, the consideration from the promise is said to be in the past. And the rule is that past consideration is no consideration, meaning to say that past consideration cannot be enforced in UK. Yeah, so you have to be very, very careful about it. If it is a past consideration, it cannot be enforced in the common law. Okay. However, there is an exception to it. Exception is that it can be enforced if there is an element of request in there. Okay. So let's say, for example, like the example that I give to you just now about the drowning case, right? So the person is drowning, and then you go and save the person. Yeah. So it is a past consideration, isn't it? Only after saving the person, you make the promise. But then let's say you save the person voluntarily. In that case, okay, the act was done voluntarily. So under the English law, that if the act was done voluntarily, then in that case, the promise cannot be enforced because the act was done voluntarily. However, if let's say, for example, in the drowning case, the person asks you to save, help, okay, because of the person asks you to help, okay, asking for help, that's why you go and save it. Then in that case, it is different. Even though it is a past consideration, it will be a good consideration because of the request, the element of request is in there. Yeah. So these are the rules of the consideration. Consideration need not be adequate but sufficient, meaning to say that as long as there is some value in it, it is okay. All right, not necessarily that it has to be the full value, economic value of it. Okay, and then consideration must not be illegal. So it has to be must not be illegal. It has to be legal. The moment that it is illegal, it will not be a good consideration. And consideration can be moved from the promisee or any other person. Yeah. So performing the existing duty means that, let's say, for example, I'm asking you, you all attending the class, okay? You are just doing the duty as a student because it is your duty that you have to perform. So it's not like you are doing me a favor by being present in the class. Yeah. Okay. Do you get the point? You are just doing the existing duty. That is what is I mean by performance of the existing duty. Example of the performance of existing duty. Yeah. So existing duty can be two types of duty. One is a contractual duty and another one is the public duty. So if it is it doesn't matter whether it is a contractual or the public duty, as long as you are doing something which you are dutifully bound and you have to do it and you do it, all right, because it is that you have to do. In that case, it will not be called as a good consideration. Yeah, you are not what is that, you cannot ask for anything additional to it because you are just performing the existing duty. So thereby here there are two cases. Okay, for the public duties there is one case, and for the contractor's duty there are two cases. I want you all to read it. Stick and Myrick, and another one is the Hartley. These are the example of the cases which explain about the performance of the existing duty. The general rule is that performance of the existing duty is not a good consideration. Okay. However, there is an exception. Exception is that it can be a good consideration if it is done over and above. Okay. Over and above means that you are doing more than what you are required to do. In that case, and it will be a good consideration. Yeah, so of course you have to prove that you are doing more than you are required to do. So that is what happened in this case in here. It is about the public duty. Yeah, here in this case was that he was he has been subpoenaed to attend the court. Okay, which is a public duty. It is a public duty that as a civil citizen, it is your duty. Whenever you receive the subpoena to attend the court, you have to attend the court as a witness and to give the evidence. So if you happen to be a witness to any crime or any sin or whatever. So what happened was that here he was told that, okay, if you attend the court, you will be given the money. The person promised that, okay, please come. Okay, it is important. If you come, I will give you the money. But later he attended, the other party refused to give. Thereby, he sued him for the promise that he made. The court said that no, cannot. Okay, because we are not doing anything over and above that is existing public duty. So if you are just performing the public duty, then it will not be a good consideration. Yeah. But it will be a good consideration if you are doing more than which you are required to. This is what does I mean by here, over and above. Okay, so if you are doing something over and above the existing obligation or duty to constitute, then in that case, it will be a good consideration. Okay, so you are doing more than what you are required to do it. Okay. For this matter, I want you all to read in these two cases, and I want you to distinguish between these two cases. For this is for the performing existing contractor duty, and this is for the public duty. Can you all please now read it now? And I will call the name to explain the case. Are you all done yet?
Not yet.
So give me the difference. What do you think of the difference between these two, for the Stig and Merrick and the Hadley and Ponsonby? This is about the contractor duty, and this one is for the public duty. Why is it that in this Collins case, the court say that, you know, it is no consideration, but in this case, the court say that there is a good consideration? Can you differentiate these two cases? Collins, and another one is the Glassbrook brothers. So here in Collins' case, what happened was that, about the subpoena case that which I explained it to you just now. Yeah. So the person is just doing the obligation that which he is required to do under law. Whether the person promised to give the money or not, he has to do it. Okay. So that is the reason he's just doing his normal public duty. That is the reason the court say that there is no consideration, because he didn't do anything over and above than his existing public duty. Whereas here in this case, the duty of the police is that they just have to guard the place. Okay, they just have to ensure that there is no, what would I say, public, there is no disturbance to the public peace or the order. So they will just make round. So what the defendant required in this case is that they want the police to be stationed at all times. So they are asking the police to do something more than what they are required to do. Under the law, what they are required to do is about, they just has to ensure that everything is in order and it is safe. But here, they want more than that. What they want is that they want the police to be stationed at their place. So here, parties agree to place stationary guard at the rate payment. Okay, so police provided the stationary guard, but later on they refused to pay. So they are saying that, I know we're not going to pay to you because you are just doing your public duty. Thereby, the case was brought to the court. So the court say that they did provide more protection than what is necessary. Okay, so they are doing more than what they are required to do. So they are doing something over and above than their duties. That is the reason that it is called as the good consideration. Yeah. So here also they are just performing the public duty, isn't it? They are performing the public duty, but they are doing more than what they are required to do. So if they are doing more than what they are required to do, it will be a good consideration. Do you see the difference from the first case to this case? Here, you are just performing the public obligation, not doing anything special. Okay, that is the reason it is not a good consideration. However, in this case, the police is providing more than what they are required to do. Okay, that is the reason, over and above than what they are required to do. That is the reason that the promise made by the other party that they are going to make the payment for the security that they have provided, they have to pay for it because they are providing more than what is it required under the law. So meaning to say that they are doing something which is over and above than which is required. So these two cases are the example for the public duty, and these two cases are Stig and Merrick and this Hadley Ponsonby. This is for the contractor duty. Yeah. So in this Stig and Merrick case, what happened is that it was on the sea voyage, and the two seamen deserted the ship. Two of them leave. Okay, so the rest of the seamen still on the ship. They go until they stay until they reach the destination. Thereby, the captain promised that the rest of the crew, after the two left, hey, please stay on here until we reach the destination. If you stay, then the captain promised that they will be given the extra wages. Yeah, but later on, the captain refused to pay. Thereby, it was brought to the court. The court held that no, these people, they are not entitled to get extra wages because they didn't do anything extra.
the fact that they are staying on the ship, which is required under the original contract, whereby they have to stay until they reach the destination. So they are not really doing anything more than what they are bound to do under the contract. So they are just performing their contractual duty only. That is the reason that, they are just performing their existing contractual duty, so they are not entitled to get any extra wages. Yeah. So that's why the court here in this case rejected the claim for extra wages. The court said that the crew already bound in contract to meet the normal emergencies of the voyage, so they do no more than what they are required to do, and they are under the contractual duty. They are just performing their contract only. Okay, nothing extraordinary that they perform. So they are not entitled to get anything extra. So the promise that they were given, that they will be given the extra wages, which is the promise, that consideration, it is not enforceable. Yeah, because they are just performing contractual duty. Whereas here in this case, the cases that the facts are similar. But here in this case, the majority of the shipmen, the seamen, they left the ship. So only a few left on the ship. Only a few stay on because of the weather. The weather was very rough. So, here the total crew was 36, out of it which many left, and only 19. So 19 is like half of it only left. Out of 19, only 5 were the able seamen. So these 5 people, five seamen, they have to take care of the ship on behalf of the whole, the seamen that which has left the ship. So they are doing something which is more than what they are required to do. Thereby, the captain promised that they will be given extra wages to work the ship, until they reach to the destination. But later refused to pay. The facts are similar, isn't it? Yeah. Now the difference is that in the earlier case, only the 2 left and majority stay on there. So they are not doing anything more than what they are required to do. But here in this case, majority left the case. Okay, so only a few, 5 of them, they have to cover the whole ship. Okay, the responsibility they have to take over for the whole ship, meaning to say that they are doing more than what they are required to do. So that is the reason the court say they are doing more than what they are required to do. So they are entitled to get the extra wages. So the court say that the ship was short-handed and voyage became dangerous. So seamen were no longer bound to serve under the original contract, and they are free to enter into a new contract. All right, so that is the reason there is a good consideration, and the promise made by the captain is enforceable. Okay. Promissory estoppel is another principle about the consideration part. Promissory estoppel, it is, it is the only situation whereby you make the promise to the other party, but the other party do not provide anything. Okay, no promises in return, but that promise is enforceable because the promise that made by that party is believed by the other party. The other party believed upon it, all right, and acted accordingly, relied upon on the promise, and they acted accordingly to the detriment. All right, so it is not fair for the promisor to go back to the original position. Okay, so this is the only situation whereby the promise made is enforceable, even though there is no consideration coming back from the other party. So here, promissory estoppel means that promises that have not been supported by valuable consideration. Yeah. However, you have to ensure all these elements are there. If one of the elements is missing, then you cannot say that there is a promissory estoppel. Okay, so the elements are there. They are promise made by the promisor. Okay, the person make the promise to the promisee, and the promisee, promisee did not give back anything in return to the promisor, but promisee believe in the promise made by the promisor. Okay, that's why here promisee relied upon the promise. Okay, and if the promisor breach the promise, promisee is going to suffer a lot of damages. So he believe in it and stay on it, okay? Act upon the promise accordingly. So it will not be fair for the promisor later on to breach the promise. So in that case, promisor will be stopped from going back to the original position. Yeah. So here, these are the requirements of the promissory estoppel. Requirements are that one party must make the promise, okay, and the other party, okay, relied upon it, okay, and then rely upon their detriment. So if the other party breach it, isn't it common sense? It will not be fair, okay. So in that case, the promisor will be stopped from going back to the original position. For this promissory estoppel, I want you to refer to the high tree case. High tree case is the case, the leading case whereby this promissory estoppel doctrine was laid down. Okay, so have a look at the high tree case for the promissory estoppel. So now we are going to move on to the next essential elements, which is the intention to create legal relation. I've explained it to you already during this last week, I think. There are only two types of agreement. One is the social, family, domestic type of agreement. Another one is the business or commercial. Okay, so whenever there is a social, family, domestic type of agreement, we need to say that a husband and wife, parent and child, among the siblings. Okay, but the court always assume that the parties do not intend to create legal relation. Okay, they do not intend to create legal relation. Whereas in business or commercial contract, then parties do intend to create legal relation. Yeah. So if you want to rebut it, meaning so that if you want to argue it, and if you want to stay otherwise, then what is stated just now, then you have to prove to the court and you have to come up with the evidence. Yeah. So for the social, family, domestic type of agreement, you have to look at the intention by the what is that parties. The court always assume that there is no intention. Yeah. Okay. And then whereas in commercial contract there is. So let's have a look at for the husband and wife. For the husband and wife, general rule is that they do not have any intention to create legal relation. They do not want it to be legally binding. And this is what happened in this case of Balfour and Balfour. Okay, I want you to have a look at the facts of the case. I want you to differentiate these facts of the case with this facts of the case in merit and merit, and differentiate it. What is the difference between Balfour and merit? Yeah. So in merit, there is the intention to create legal relation. Yeah. So why is it that in Balfour there is no intention to create legal relation, and why is it that there is intention to create legal relation in merit? Who can answer this question? Anyone? If you can answer, you will be given 1 mark.
Madam, is it because there's a document signed?
No. No.
Is it because it's a legal contract regarding property for merit and merit?
No.
Is it because in the married and married case there is a divorce?
What do you mean by that? What do you mean by that? Can you please explain?
Since there is a divorce, so there's no longer a close or family relationship. No domestic relationship anymore after the divorce.
Okay, the main point in here is that, yes, the general rule is that the promises made between husband and wife, there is no intention to create legal relation. However, if the promises are made, if they are about to divorce or separated, okay, in that case, the promises made between the husband and wife, there is intention to create legal relation. Everyone get it? So here, the court say that they had a binding contract and intention was present. Because when they are about to divorce or separated, whatever that they say, they meant it to be legally binding. So whenever you look at the promises made between husband and wife, you have to look at the situation, whether they are in normal marriage relationship or they are about to divorce. Okay. Okay, Lee Hao San. So I give you 1 mark for that. So here for the commercial agreement. For the commercial agreement, there is intention. Okay, there is intention. So if you wanted to prove that there is no intention, you have to prove it. You have to convince the court that there is no. So this is what happened in this Edwards and Skyway. So what happened was the employee was asked to leave the company, and the company said that, okay, you resign, and if you resign it, then we will pay you the money. Okay, so the employee resigned. After he resigned, they refused to pay the money because thereby they argue that we cannot pay it because of in the letter that they issued to him, they put it there, ex gratia payment equivalent to the company's contribution. So they argue that the company argued that because of the word ex gratia in here, they don't have any intention to create legal relation. That's why it's just, they cannot pay. They cannot pay the money. You need to say that the promise made by them is not legally enforceable. But the court say that this is a commercial agreement. Okay, this is between the employer and employee. So if you want to say that there is no intention to create legal relation, then in that case you have to inform. And you have to make sure that the other party is aware of it. Here, by using the word the ex gratia, what is the meaning of ex gratia? Layman will not understand, so it will not be fair to, say that there is no intention to create legal relation. So this is because it is a commercial type of agreement, you see. So whatever commercial type of agreement, the court will always assume that there is intention to create legal relation. And if you don't want it to be legally binding, you have to convince the court and you have to make sure that the other party is aware of it. So here they didn't do it, okay? So they do not have any evidence to rebut it, so they have to pay for it, yeah? Certainty of the terms, this is another important element. The terms must be certain. So it has to be certain, means that it cannot be vague and very wide. Let's say, for example, if I have 2 cars, then I'll tell you that, hey, I want to sell you my car. I didn't mention which car, okay? Thereby, you're not sure which car that I'm referring to. I didn't even say what is the amount that I'm going to sell it to you, or when is it going to sell. The details of it. The terms are not clear. It is very vague and wide. That in that case, it will not be enforceable. You will not be able to enter into the contract. Yeah. So the terms must be certain. It has to be stated clearly. The next important element, which is very important, is the capacity of the parties. The parties must have the legal capacity to enter into the contract. Legal capacity means that the person must have attained the age of majority. Everyone know, right? Age of majority in Malaysia is 18. Yeah, 18. So those who are under the age of 18, they will be called as minor. A minor under the law, from the legal perspective, they are, they are deemed to be like they are weaker party compared to the adult, meaning to say that they don't really know about anything about the law. So the law protected them. So those under the 18 are regarded as a minor, and then they are protected under the law. So that's why they do not have the legal capacity to enter into the contract. Yeah. So if they wanted to do anything, they have to be represented by the next of kin or the guardian. So which has the legal authority to enter into it. Yeah. So legal capacity is very, very important. If you do not have a legal capacity, you cannot enter into the valid agreement. So minor, drunkard, if you say that drunkard means that you do not have the clear mind. Okay, you don't know what is going on. So those who are drunk, their mind is clouded, and they can't think clearly. So let's say, for example, a person signed a contract while the person was drunk, that contract can be invalidated, can be challenged. The validity of the contract can be challenged because if a person is drunk, cannot enter into the contract. So capacity is also a very, very important essential elements. So if do not fulfill the capacity, they don't have the legal capacity, then again the contract will become void as well. Okay, another one is the bankrupt. Okay, because under the law, it is they do not have the capacity. Yeah, so you have to be very, very, very careful about this valid, void, and void whenever minor enter into the contract. One of the important part about the minor is that okay, this one it's not included in here. They are the exceptions when the minor enter into the contract and it is valid. These are the scholarship agreements. Okay, this one I think I explained it to you a little bit briefly during our second lecture, if I'm not mistaken. It's about the Government of Malaysia and Gujarat Singh case. It's about the scholarship agreement. Yeah, after the case, the contract acts was amended, and so all the scholarship agreement from there on, it is enforceable, or it is even if it is entered into by a minor. So scholarship agreement it's an exception. Another one is about the for the insurance, under the Insurance Act, and the apprenticeship, and the another one is marriage. Okay, of course it has to be represented by the guardian or the next of kin. Another one is that you have to be very, very careful whenever a minor enters the contract, whether it is for necessaries or not. Okay, so if it is for the necessaries, then in that case, the adult has the right to reimburse back the money from the minor. So let's say, for example, a minor go and buy something for buy food at the restaurant. Okay, after eating, he doesn't have money to pay. Okay, is the contract valid or not? The contract is void because it's a minor. However, what is the object of this contract? The object in this case is that it's food. The food is regarded as a necessary. Necessaries means that a thing which is beneficial to the minor, which is essential to the minor, which the minor needed. All right. So how would you know that whether a certain thing is essential or not to a minor? That one you will look at the type of the food, the type of the you know of the object, and the whether the lifestyle of the minor, based upon which you will decide whether it is it's necessary or not to a minor. Yeah. So for this matter, I want you to have a look at the case of Nash and Inman. So in Nash and Inman, I'm not sure whether I explained it to you all. I think I did, right? It's about a minor go and make a coat at the market. He's coming from a very rich family. He's at the Cambridge, studying at the Cambridge, and then he needed a coat, so he go and make himself a coat. After that, he refused to pay. Thereby, he was sued for the payment, and brought to the court. He argued that, oh, sorry, you cannot sue me. I'm a minor. Thereby, the court has to decide whether the coat it's necessary or not. If it is necessary, then he has to pay for it. The adult has the right to reimburse back the money. However, if it is not necessary, they cannot get anything. So in this case, in Nash and Inman case, the coat is decided as not necessary because he has such type of clothes. All right, plenty. So he does not need another one. Okay, so that is the reason it is decided as not necessary. So the moment that if it is not necessary, then he doesn't have to pay for it. So it is a little bit weird, right, the situation. So you have to be careful whenever you solve a case study question whereby a minor is involved. Then you have to look at whether the situation that he is in, whether things or the services that he acquired is whether it is necessary or not necessary. Yeah. So if it is necessary, then minor has to pay for it. If it is not necessary, then he doesn't have to pay for it. So you have to be careful about this one. Yeah. So another one important part is the terms of the contract. Terms means that what is written in the contract. So let's say, for example, when I ask you about the example of the contract which you have entered into. Most of you have given me the example of like renting the house. So in renting the house, what are the terms of the contract? So how long is the the period of the contract? How much is it that you are renting for? When is it that you have to pay? And how is it that you have to pay? And then all the terms of which is the tenants have to follow, and what the landlord has to do. These are the terms of the contract. Okay, and these are important part of the contract, because if you do not fulfill all the terms of the contract, yeah, you have the right of action against the other party. Okay, so thereby you have to, there are the different types of terms. There are some terms are called as conditions, and some are called as warranty. Yeah, some are called as condition, and some are called as warranty. Condition means that the terms which are the root of the contract or essential part of the contract, it is called as condition. Essential part of the contract means that these are the important part of the contract. It is so important that if you breach the condition, the terms which amount to conditions, if you breach it, then the other parties even have the right to terminate the contract, in addition to ask for the damages. Whereas if the terms are just regarded as warranty, warranty means that it's the less important part of the contract. The terms are not as important as condition, less important. So since it is less important, if you breach it, you can just sue the other party for the damages only. Damages means that you can sue just for the monetary compensation, and you cannot terminate the contract. Yeah, so in that case, it will be called as a warranty. So these are different types of terms that you have to be familiar with. So because if it is a warranty, you can ask for damages alone. If it is a condition, you can ask for both damages and terminate the contract, because it is an important part of the contract. So even among the condition, they are called express and implied. Express means that, like the terms that I give you the example just now, it is stated clearly in the contract. So let's say, for example, if it is a sale of a car, so all the important terms that which are stated expressly, write it down there in the contract, in the written contract that you will see. These are the express terms. Okay, implied terms means that you don't have to write in the contract, but it is applicable automatically because it is stated under the statute. So for example, like for the consumer contracts, all right, or the sale of goods contracts, you don't have to mention that there are certain terms that which you have to write and put it and include it in the written contract. You don't need to, but under the Sale of Goods Act, for example, it is stated clearly, these are the implied terms. So whenever there is a contract relating to the sale of goods, these implied acts will be automatically applicable. Yeah, so implied terms means that the terms which are stated under the statute, some of the statutory provisions, okay, so you don't have to list it in the contract in there. So that is what I mean by the terms that I was explaining about. Yeah, so the terms are the important part. Yeah, so it must be these terms are important, because if you breach it, you have the right of action against the other party. So what happened was that sometimes people don't want it to be sued by the other party. Thereby, they use the exclusion clause to avoid from the liability. I'm not sure how many of you have come across exclusion clauses before. Have you encountered any exclusion clauses before? Any one of you?
Park at your own risk.
Very good. That is a perfect example. Park at your own risk. Okay. Exclusion clause, usually you will see in the tickets, bus tickets, plane tickets, train tickets, or even you go to the park, you will see that, they will not be held to be liable. Even at the hotel or any premises that you are visiting, sometimes you will say that, you come in, it is your liability, anything goes wrong, they will not be held to be liable. So the easiest example is the parking one. Okay. So park at your own risk. Okay, it is the exclusion clause. We need to say that you park there. If anything goes wrong with your car, you cannot sue them. Okay. These are the exclusion clause. They exclude themselves from the liability. So anything goes wrong with your car, you give up your rights of action against the other party. So you have to be very, very careful whenever you enter into the contract, whether there is any exclusion clause or not. Yeah. So if it is in the written contract, usually exclusion clauses are stated in the contract itself. So you have to read. So let's say, for example, it is stated in the contract, and just because you did not read it, but you just sign it, but the moment that you sign it, you are bound by all the terms. So even if you do not read it, that clause still will be applicable. And in case anything goes wrong, you cannot sue the other party. Yeah. So this is in the written contract. What about if it is conduct, the contract that you enter into by conduct, like in parking case, whereby you don't need to enter into any written contract? Well, how do you park the car? You go into the parking place at the machine, you take the ticket, your car will just go right, drive in, and then you park the car. All right. So at what point of time the contract is completed in this situation? It is the time that whereby you park the car at the parking place, or is it the time whereby you take the ticket from the machine at the entrance there? Okay. When do you think that you enter into the contract? Anyone? Hello? Hello?
When you park.
No, it is when you take the ticket. So the moment that you take the ticket and you enter into it, you are entering into the contract already. So if they want to put any exclusion clause, they have to make sure that they give the exclusion clause before you enter into the contract, or at the time of the contract, and not afterwards. Okay, not afterwards means that you cannot give it after the contract is completed. So if the contract is completed at the entrance, that once you take the ticket and you park, you enter, you take the ticket from the machine, and then when the bar go up, you enter into it, you are accepting all the terms. Okay. So if the exclusion clause, in one case, in one of the decided case, what happened was that the person go and park in the parking. All right. So at the wall in the parking, it was stated as park at your own risk. Okay. So he went up to the building to attend a meeting. After coming back, he's found out that his car was damaged. Thereby, he sued the owner of the parking place, and the parking owner said that, sorry, you cannot sue us. They are the exclusion clause saying that park at your own risk in the building, stated clearly. So you cannot sue us. Okay, they are the exclusion clause. But the court said that you will see these exclusion clause only after you enter into the building, which is after you have entered into the contract. So before you enter into the contract, you do not see what are the terms. Okay, so since the notice was given only after you enter into the contract, they say that it is not a part of the contract and it is not valid. It cannot be relied upon. So it is not effective. Of course, that is not only thing that the court will look at. The court will look at any past dealings or any business dealings that whether they have entered into before or not. In another decided case, what the name of the case is the Oli and Marlborough. What happened in this case was that they go and stay, this couple go and stay at the hotel. And then at the hotel, they leave their belongings and then they went out. And after that they came back, they saw that some of the belongings are missing. Thereby they sued the hotel. And the hotel said that, sorry, you cannot sue us. Look at your room, your hotel room behind the hotel room, the door, behind the door, there are the terms and the conditions stated there. There is the exclusion clause stated there clearly. The hotel will not be held to be liable. The court decided that at what point of time the contract is entered into. The contract is entered into at the cashier, at the reception, whereby you give the money and they give you the room, the key to the room. That is the point of time whereby contract is completed. So when do you see the exclusion clause? So if they want any of the exclusion clause to be applicable, they have to ensure that they give it at that time. all right, at the time when they enter into the contract or before entering into the contract, but not afterwards. Here, they give the notices only after they enter into it. So which they see only after they enter into the contract. So it is not a part of the contract, so they cannot rely upon it. Yeah. So this is whereby we are talking about the contract by conduct. Okay. And then in ticket cases, it is very common use. Yeah. So you have to be careful about all. So it is not only one factor. So you have to look at any past dealings, whether the person has stayed in this hotel for before or not. So in another case was that the facts are very similar, but the person who stayed in the hotel he is a hotelier himself, and he stayed in the hotel for several times before. So he is already well aware of the fact that there are the terms and conditions stated in there. So in that case, the court said that these terms are effective. So it's not only that, one factor that the court will look into it, they will look into the whole thing. There are some other factors also the court will look into as well. Yeah, that is whereby whenever you enter into the contract based on the by conduct, all right, and not a written contract. In written contract, is clear cut. The moment that your signature is there, whether you read it or not, exclusion clauses are there, it will be effective and it will be applicable. But by conduct or the other type of contract, you have to make sure you give the notice at the time or before you enter into the contract and not afterwards. Okay, so in the ticket cases, let's say for example, like in bus tickets, train tickets, it is the trade common usage. So usually what the tickets usually is that behind the tickets, it is a common usage of the trade is that they will put the terms and conditions in there. So even if you do not read it, okay, so if you got the ticket, you give the money, you got the ticket, even if you don't read it, it still will be applicable, and these clauses will be still applicable. So you have to be very, very careful about all these exclusion clause. In one decided case, it's with the MAS. It was quite many years ago. It's about the plane ticket. Yeah, so there was a delay of the flight and the rescheduling and all. Thereby, the passenger sued the plane. The plane company, and then but of course they lost the case because the court said that the terms are applicable, it is part of the contract, okay, because it is the common trade usage. So they will look at all these criteria, all the other factors, okay, but for it to be effective, it is very, very important because it must be a part of the contract, and to be a part of the contract, the notice has to be given to the other party at the time or before entering into the contract. And the court put a very heavy duty on the person who wants to rely upon these exclusion clause to put the burden on them to they have to ensure that the other party is aware of the existence of these exclusion clauses, because the moment that these exclusion clauses are effective, the other party totally lost their legal rights. They don't have any rights of action against other party. So they are giving up their rights of action, you see. So the court gave the very heavy duty on the party who wants to use this exclusion clause to prove that they have given the sufficient notice to the other party, all right, before at the time they enter into it. Only then it will be effective. Another thing important is that here oral contract. Oral contract is that, right, oral contracts, whereby the parties enter in by words of mouth, okay, by the statements, okay. Written contract means that it is written it down you have to sign by the parties. So sometimes what can happen is that, okay, there is a written contract in there, okay, written contract whereby you sign, but before you sign, the two parties, they discuss each other. So let's say, for example, if there is a sale of a house, so the party A and party B, party A is the seller, B is the buyer. So B, before signing the contract about the sale, all right, written contract, before signing it, so B may ask a few questions to the A. So A will tell things about the house to B. So what will happen to these statements that which they talk each other, they make before they enter into the contract? These will be called as the representation. Representations means that it's the oral statements that people made before they enter into the contract. They do not form part of the contract, okay? They are not a term of the contract. And that's why if there is a breach of just this representation, you cannot sue the other party. So if it is just a mere representation, just talking to the other party, it will not be a term. It will not be a part of the contract. However, the interesting thing is that if that oral statements that the people made, let's say, for example, the seller made, if that representation, the oral statements, if it is amount to a promise, and if that promise convince the other party to enter into the contract, to the written contract, and make the other party sign it, in that case, that representation will become a term of the contract. And if the party breaches it, the other party has the right of action. So you have to look at carefully about the representations that the people made, the seller made, before they enter into the written contract, whether they are just a mere representation or they are a term, okay? If they are just making a statement, just a normal situation, just making and talking, then it will be just a mere representation. However, if the statements amount to a promise and convince the party, and because of the promise, the person make the promise that the other party agree to sign the contract, then in that case, the promise will become a term of the contract. And if there is a breach of it, you can sue the other party. It is as if like the person has breached the term of the contract. Let's say, for example, there is a sale of a house, okay? So the buyer, before signing the written contract, asked the seller, hey, this house look old, can you paint or not? If you paint, then sure, I will buy it. Okay, so you make the statement. Thereby the seller say that, oh, don't worry about it. I promise you I will paint the whole house, okay? Or just sign the contract, I'll make sure that I'll paint it. So because of the promise that the seller made that, okay, he will paint it. So the buyer signed the contract. After signing the contract, after a month or so, a few days, he go and check, wanted to move in. He found out that the house is still not painted, then in that case, he can sue the seller. The seller cannot say that, hey, it's just a mere representation. It's never been written in the written contract that I will paint the house. I never stated that. But that is the promise, even though it is the oral statement. That statement amount to promise, and that promise convince the other party to enter into the contract. So you have to be able to differentiate, what amount to a mere statement, mere representation, and what amount to a promise. Everyone get it? Yes or no?
Yes.
ma'am.
Okay, so these are explained it just now already, exclusion clause. So this is the example about the written and signed contract. Okay, so here it's about the this is a perfect example about the written contract. So what happened in this case was that the terms, the exclusion clause was written in very small print, but the thing is that the person never read it before he signed, but the signature was there. So the court say, you signed it already. You cannot argue that you didn't read it. But the moment that your signature is there, so don't simply sign. Before you sign, you make sure that you read it. Yeah, because once you sign it, it is deemed that you have read it. Now, whereas if it is unsigned documents, okay, whereby you don't need to sign, like Oli Marlborough case, this is the case that I explained to you just now. The notice has to be given before or at the time of the contract. Okay. Any questions so far? Oh my God, 6:15 already, so fast. Any question? Hello? Oh, yes, Wong?
Madam, I'm just curious. Earlier you said that when they promise to paint the house verbally, how can we prove it? Or-
Of course, yes, that is a very good question. Because in law, okay, theoretically we say that, yeah, this is the. In practical, in practicality, in real world, the most important thing is what? Evidence. Of course, you should be able to, you must have the evidence to prove that. Let's say, for example, there is a witness that who is there, who also hear about the statement that you made. So that is the reason that people prefer to put it down, everything in writing form, because that is the easiest way to prove it. So if it is oral, you have to be very, very careful. You either record it or you have the evidence to prove that the person made the statement. Because in the eyes of law, in the end of the day, what is important is that whether you can actually prove what the, about the statement that what you have made. You have to prove it, of course. Okay.
Okay, madam.
So this come to the last part of the contract part. Okay, we have covered all these essential elements already. I'm thinking of giving you all the assignment based on this last part. This because these are called as the vitiating factors. We call it as the vitiating factors because these are the factors that which can affect the validity of the contract. Because the moment that once you can prove that there is the existence of any of these elements, you can say that the contract is void or voidable. Okay, so the effect is quite what would I say? Quite big in the sense that it can affect the validity of the contract. That's why we call it as a vitiating factors, the factors which can affect the validity of the contract. So I'm thinking of, I haven't decided yet. I'm still thinking what I wanted to give something which is really interesting and which will invoke your curiosity and do the research, and you actually will go and look for it. So I haven't decided yet, but I was thinking of something relating to one of these factors, but not sure yet. Yeah, but I will finalize it and we'll put it up on in the Google Meet Google Classroom by this week. So okay, vitiating factors means that the factors which can invalidate the consent, the freedom of the consent, because the most important part is that in the contract, for you to be able to enter into the valid and legally binding contract, the consent must be free. It cannot be influenced by any other factors. So you enter into the contract, you enter it because you wanted it. Let's say, for example, you attend the class because you wanted to learn, and it's not because that you are worried about your attendance and you're barred from the exam kind of thing. So you get the point. You are doing it willingly at your free own will. You do it because you wanted to do it. Okay, so there must be a free will and free consent. You must have the freedom to enter into the contract. Only then the contract will be a valid contract. So these are the situations which will affect this freedom of consent, freedom to enter into the contract. Let's say coercion. Coercion means that you force the other party to enter into the contract. You force the other party, you threaten the other party. So either by a knife or by force, or you make the other party to enter into the contract. So it's not because that the other party wanted to enter into it. They enter because they are scared of it. They are being forced to enter it. So the moment that you can prove that there is an element of coercion in there, the contract will become a void or voidable. So it calls as a void or voidable means that it gives the option to the parties whether they wanted to make it valid or void. Okay, void or voidable, give the choice to the party. So let's say, for example, A and B. A threaten B to enter into the contract to sign it. B sign it. So let's say, for example, it's about the sale of a car. So B agreed to sell the car to A. So there is an element of coercion in there, but B decided that, okay, it doesn't matter. Anyway, I wanted to sell it. Yeah. So he just let it go. He doesn't want to take the action. So it's given a choice to B whether B want to make it void or voidable. Okay, whether he wants to make it valid or he don't want it to be, he wanted to be void. So that is the reason it's called voidable. Okay, that give the option to the parties whether they want to choose it this way or that way. So it's up to the parties. So the parties who has been affected in such a way have the choice. Sometimes they may say that, okay, doesn't matter, they just want to continue with it, then in that case, yeah, they can just validate the contract. And then if it is not, then it will become a voidable contract. It will become void. Okay. Another one is undue influence. Undue influence is usually like you influence the other party and duly improperly influence the other party to enter into the contract. So the other party enter into the contract not because that they wanted to. Somehow they have been forced. But here, more on like here for the undue influence is different from coercion, is that it is totally different. Yeah. For the undue influence, there be like two parties whereby one party is in a higher position and higher authority kind of thing, and the other party is in a weaker. So it can be a weaker in emotional sense or the physical sense as well. Let's say, for example, old elderly people, those who dependent upon their caretaker, all right, you can say that there is an element of undue influence in there because they have to depend very much upon their caretaker, and let's say suddenly they transfer all their property to the caretaker. There's a question as to the validity of that type of contract, whether there is any element of undue influence or not. Now, another type is that you can see is that, let's say, for example, a religious teacher and the follower, whereby the follower, because of the faith and belief, they do whatever the other party, the leader say. Let's say, for example, it is in decided case as well, whereby the follower transferred all the property to the religious teacher, but the person is not happy with it. Yeah, thereby later on challenge on the ground of undue influence, or they have been influenced to enter into the contract. There are a number of cases actually. For this vitiating factors part, you can, for the detail, you can refer to the notes. Yeah, I have given you all the notes. You can have a look at it. And these section 15, 16, 17, 18, all these sections are under the Contracts Act. Yeah. If you refer to the Contracts Act, you will see the sections explaining it clearly and the explanation to it with the examples as well. Fraud is more on like, you are making the other party to enter into the contract, concealing the truth, and you make the other party. You know that it is wrong, but you do it purposely to make the other party to enter into the contract. That is the fraud. So let's say, for example, like, fraud as to the date of the date of birth, or the fraud sign of you signed another person's signature. All these are fraud. You know, right, what is fraud, right? So you know that it is wrong, but you do it purposely with the intention to convince the other party to enter into the contract. Okay, that is the fraud. Misrepresentation is more like the oral statements, the statements made by the party, by the person before they enter into the contract. So misrepresentation in Malaysia, actually there are three types. One is the innocent, fraudulent, and the negligent. Innocent misrepresentation means that you make the statement is wrong, and you do not know whether it is right or wrong, but you just simply make the statement. Okay, you honestly believe that what you say is true, but the statement is wrong. So that is what does it mean by the innocent misrepresentation. Okay, fraudulent misrepresentation means that you are making the statement whereby you know that it is wrong, but you intentionally made it to convince the other party. So the difference between fraudulent misrepresentation and fraud is that fraud is more on the act, conduct itself, okay, concealing the truth. Whereas fraudulent misrepresentation is that more on the statement of which you made with the intention of convincing the other party to enter into the contract. Another type is the negligent misrepresentation, which usually used for the professional negligence type of thing, whereby you make the statement, you do not care whether it is right or wrong. Maybe maybe you may have a doubt about it, the truth about it, but you just don't care. You make the statement. Thereby, the statement that which you made, is wrong. It's a negligent misrepresentation. Mistake is more on the mistake of identity or mistake of law. Yeah. So let's say, for example, you see on the Facebook, you see the picture and you fall in love. But when you actually go and see the person is another person. It's a mistake of identity. Yeah, kind of thing. Or mistake of law. Mistake of law is not an excuse. Yeah. You cannot say that, oh, sorry, I do not know about this law. You cannot say mistake of law. It's not a defense. So let's say, for example, you go to Singapore chewing gum it's illegal, right? You're not supposed to use it. So you cannot say that, oh, I do not know about the law of the country. Yeah, still will be guilty of it. And these are the remedies of the breach. Remedies means that right, that the court give the remedies, compensation in a way, or the what the court think that which the party should get it whenever there is a breach of contract. So there are a variety of remedies which are available in law of contract. So out of these remedies, whichever is most appropriate will be given by the court to the parties concerned. Yeah. So recession is the canceling the contract. Restitution means the restoration, means that the parties will be put back to the original position as if nothing had happened. Okay. Damages is the monetary compensation in money form that they have to pay to the other party. Specific performance is usually it is given whenever there is the damages alone is not sufficient remedy, then the court will add additional remedy, which is the specific performance, which is that the court will ask the parties to perform the contract. Okay. Let's say if it is for the sale of a house and there is a delay in transferring the house. Okay. So because of the delay, you have to go and rent the house, right? So for the renting of the house, they have to pay for the damages compensation for the extra expenses that you incurred because of the breach of the contract. The other party will have to pay. And in addition to that, the court will ask you to perform the contract as well. Yeah. And the last one is the injunction. Is usually the order given by the court. Okay, restraining the party from doing something. Let's say, for example, if it is for the restraining order, yeah, I'm not sure whether you come across, the court will ask the party from doing something. Yeah, they will give the injunction to it. Okay, that's all about the contract. And with this, we finished the law of contract already. Now, do you have any question? Do you have any question?
No, madam.
I'm sorry, I don't know whether I talk too much today. I just want to finish this chapter, but I want to make sure that everyone understand. Do you understand?
Yes, madam.
I will stop recording. Yeah, okay, I will check whether you actually understand or not.